as you analyze the cases, these are items that are things that are used to prosecute individuals. The fundamental case on the subject is not really, it starts at Crawford, but it's really Palmer versus Hoffman, which is I believe it's a 1950s U.S. Supreme Court case that basically says that anything that is going to be used to prosecute somebody in court is testimonial in nature.
Now, here's the facts of the case, very straightforward. Mr. Crawford is married to a young lady, very pretty. I'm going to try to make this more interesting than it really is, named Sylvia. And Sylvia had some type of an interaction with a neighbor, who I think his name was Ken. And during the course of that interaction, Ken tried to, according to Sylvia, sexually assault her. Sylvia did what many people do in Washington. Instead of calling the police, went home and told her husband, who immediately did what a lot of people in Washington do. Instead of calling the police, went over to confront Ken and discuss this with him. During the course of the discussion, I'm not quite sure what happened, but knives were pulled, and Ken wound up getting stabbed. The police responded and arrested Mr. Crawford. They also took Sylvia into custody as well to, first of all, get her side of the story, but also make a determination as to whether or not she had participated as a co-conspirator or an accomplice or something of that nature. There were statements given by Mr. Crawford in terms of his side of the story. Mr. Ken, the perpetrator in all this, actually survived his wounds, but there was a charge of aggravated assault, attempted murder, and things of that nature. The police took a very, very long and involved statement from Sylvia and recorded it. Okay, so they kind of wanted to lock her into a story so as to kind of eliminate the possibility that Mr. Crawford could claim that this was self-defense. All right, so this was kind of like the police strategy in winning the case. The case went to trial, and at trial, Sylvia was unavailable to testify under a marital privilege type statute that they had in effect in Washington at the time. So she just was not going to testify. He had the right to keep her off the stand. As a result, the state went forward and used her recorded statement as the evidence against Mr. Crawford. Now, the idea behind this was that the judge found it under Ohio versus Roberts to be recorded, entirely reliable, and under their hearsay rules, it would come in as, I think they brought it as a declaration against interest because she could have been charged by being a conspirator because she actually took him over to the house where he perpetrated this assault. In any event, it was admitted under their local hearsay rules. He is found guilty, and the rest of it goes to the Supreme Court. So let's take a look, see what the Supreme Court says. Justice Scalia.
Petitioner Michael Crawford stabbed a man, as we just heard, who allegedly tried to rape his wife, Sylvia. At his trial, the state played for the jury Sylvia's tape-recorded statement to the police describing the stabbing, even though he had no opportunity for cross-examination. The Washington Supreme Court upheld petitioner's conviction after determining that Sylvia's statement was reliable. The question presented is whether this procedure complied with the Sixth Amendment's guarantee that, in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. Petitioner countered that state law notwithstanding, admitting the evidence would violate his federal constitutional right to be confronted with the witnesses against him. It does not bar admission of an unavailable witness's statement against a criminal defendant if the statement bears adequate indicia of reliability, must either fall within a firmly rooted hearsay exception or bear particularized guarantees of trustworthiness.
This is the Ohio versus Roberts decision, and of course, the indicia of reliability when you're talking about a recorded statement is very, very high.
The trial court here admitted the statement on the latter ground, offering several reasons why it was trustworthy. Sylvia was not shifting blame, but rather corroborating her husband's story that he had acted in self-defense or justified reprisal. She had direct knowledge as an eyewitness. She was describing recent events, and she was being questioned by a neutral law enforcement officer. The prosecution played the tape for the jury, relied on it in closing, arguing that it was damning evidence that completely refutes petitioner's claim of self-defense. The jury convicted petitioner of the assault. The Sixth Amendment's Confrontation Clause provides that in all criminal prosecutions, the accused shall enjoy the right to be confronted with the witnesses against him. We have held that this bedrock procedural guarantee applies to both federal and state prosecutions. As noted above, Roberts says that an unavailable witness's out-of-court statement may be admitted so long as it has adequate indicia of reliability, that is, falls within a firmly rooted hearsay exception or bears particularized guarantees of trustworthiness. Petitioner argues that this test strays from the original meaning of the Confrontation Clause and urges us to reconsider it.
Now, right here, you should have known how the case was going to come out, because when you see original meaning and Scalia in the same paragraph, okay, I mean, you know what's going to happen. Interestingly, though, I mean, interesting to this case is that Justice Scalia was joined by a very wide variety, from political standpoint, of the other justices, including Justice Ginsburg.
Well, yeah, if you also think about who Scalia is, it's actually very interesting because he's so conservative. But this seems to be, at least from the practitioner's perspective, a very liberal interpretation of, hey, you got to bring these people in to actually address these issues rather than do it on paper. The right to confront one's accusers is a concept that dates back to Roman times. The founding generation's immediate source of the concept, however, was the common law. English common law has long differed from continental civil law in regard to the manner in which witnesses give testimony in criminal trials. The common law tradition is one of live testimony in court subject to adversarial testing, while the civil law condones examination in private by judicial officers. Various formulations of this core class of testimonial statements exist. Ex parte in-court testimony, or its functional equivalent, that is, materials such as affidavits, custodial examinations, prior testimony that the defendant was unable to cross-examine, or similar pretrial statements that declarants would reasonably expect to be used prosecutorially. These formulations all share a common nucleus and then define the clause's coverage at various levels of abstraction around it. Regardless of the precise articulation, some statements qualify under any definition, for example, ex parte testimony at a preliminary hearing. Statements taken by police officers in the course of interrogations are also testimonial under even a narrow standard. Police interrogations bear a striking resemblance to examinations by justices of the peace in England. The statements are not sworn testimony, but the absence of oath was not dispositive. Cobham's examination was unsworn, yet Raleigh's trial has long been thought a paradigmatic confrontation violation. In sum, even if the Sixth Amendment is not solely concerned with testimonial hearsay, that is its primary object, and interrogations by law enforcement officers fall squarely within that class.
So the court is now getting into this concept of testimonial evidence. And I have to tell you at the outset here, Justice Scalia does, and I'm saying this in retrospect, a very, very bad job of explaining the concept of what testimonial evidence is going to be. I think that it was just kind of beyond their ability to explain it to people in a way that police and prosecutors and normal lawyers can understand what they were talking about. He gives it an attempt here and gives a couple of examples, but they just want to leave it to another day to get into the nuts and bolts of what constitutes testimonial evidence. In order to answer that question, you'll see they did something which was recently copied by the New Jersey Supreme Court. The next major case that they did, which we'll be talking about momentarily, is Davis versus Washington. And word had gotten back to the Supreme Court of the United States that people don't understand what they're talking about. I mean, they know this is important, but it's just not clear what they mean by testimonial evidence. So you'll see in the Davis versus Washington, the next case, they take two different fact patterns and compare and contrast them, indicating why one would be an example of testimonial evidence and why the other would not be an example of testimonial evidence. But they needed a second case to kind of go on and explain this. This is the beginning, though, of their idea about trying to define what testimonial evidence is and explain how this works with respect to the Confrontation Clause.
The historical record also supports a second proposition, that the framers would not have allowed admission of testimonial statements of a witness who did not appear at trial unless he was unavailable to testify and the defendant had had a prior opportunity for cross-examination.